Is that I get to be a pedestrian. My voice is loud enough. You won't even need this. But anyhow, I remember in the 176 earlier, either late last year or earlier this year, as time flies by, one of the lawyers who was about to pick a jury came up to the bench as I was walking by in my earshot and said, man, it's a good looking panel out there. And I'd walked past the panel, it was pretty diverse in that first 25. And he said, and the state has moved the shuffle as if all options were out. And of course, me being who I am, I said, so what, you got Batson? Smack, can I say it? Smack that ass with Batson. And so Judge Webb Bond, of course, was the court, and she was standing there. I said, excuse me, Your Honor, I didn't mean to interfere, but I did. So she smiled. But what you have to do is put the state on alert, okay? You've got that initial sheet of how those jurors were lined up. And you know on that card, it doesn't have anything but their name, their race. Does it have address on there? The bare minimum. You won't know anything about that juror, but you damn sure know what race they are, what demographics, what gender. You'd know that. And so that is an artful way of getting around Batson if you're the state, because the initial Batson only dealt with impermissible use of peremptory challenges. But Powers v. Ohio has expanded it out. You can make that third-party equal protection claim. You damn well need to do it, okay? Because Section 35261, I think it is, of the Texas Code of Criminal Procedure, and not so long ago, as I was reminded by a black male juror in my last state trial that I prosecuted, that only applied to clinically Caucasian panels. That's what the CCP was about. So you are the last chance to get this crap right, get this shit right. I'm just going to say it. You're that last chance. So it is greater than your client, okay? You got people that are taking off work, missing jobs, riding the bus, dealing with bad Houston weather to get down here and do their civic rights. So you offer that full sheet, that initial original sheets that you're given of that information as proof. And I like what Alvin did, but I also believe in scorched earth. I would ask that judge to bring that original lineup of jurors in that courtroom, sit them down, and ask each of them for the record, what's your name? What's your jury number? By the way, are you a female? Are you black? Are you Latino? Probably won't do it. They probably won't agree to do it. But remember, you get to have the last word as defense. So even if they come in realigned, you get up, tell them how important their service is, tell them how civic-minded they are, and then go back to that original group. Juror number so-and-so. You're now jurors in whatever that first two rows would have been. By the way, what is your race? And you keep doing that because you've now put the judge on alert, the prosecutor on alert, and the neighboring jurors around that person on alert. So if those 12 people don't look like those individuals who are now shuffled to the back, they know.
One thing, and I'm leaving, and I forgot to say this, and this is important too. If they strike 3, but you get 2, their fallback argument is, Judge, obviously I didn't engage in race because 2 made it. Batson is clear. You get to challenge if you believe just one juror was improperly excluded, okay? So don't let them, I mean, it's just a good day if you got 3 on there, but if you're entitled to 4, then damn it, go for your 4th one, okay? So I just want to make sure y'all understand that. Don't allow them to say, I didn't engage because there are 2 of them on there anyway, okay? That's impermissible. Batson say it is improper to exclude one person for an impermissibly, constitutionally protected group, okay? Okay.
Now, most lawyers don't come when they're in trial, but Alvin took time out to try to come. And because he's leaving, I want to ask, because he's leaving, even though I'm not trying to impose on anybody else's time, brother, and I appreciate you letting me know. But if anybody has any questions for Elvin, because he's not going to be here at the end. If anybody has any questions for Elvin, ask them now, because he's not going to be here at the end. We'll hold our other questions till the end, but he's leaving now. Anybody have any questions? Thank you, brother. Thank you for coming. All right. All right. Well, thank you. Thank you for coming. Next up, we asked these two brothers, and like I said, both of them could stand by themselves when they're speaking. Both of them. Either one of them could be a highlight of a CLE by themselves. But just to show you the humility that these brothers have, they were gracious enough to be able to share their time together and talk to you about a topic that I think is very important, and it's about the history of Batson. It's about the history of Batson. What was happening before Batson versus Kentucky ever came about? What was going on down here? And these two courthouse legends, one of them is Craig Washington, who's a courthouse legend, who's been down here since before I was born.
Before God. Before daylight.
Just about. But just right after daylight, he's been down here. And Craig Washington's one of the brothers who, if any of you ever been to Jackson County, and I went out and I handled a case in Jackson County dealing with Bobby Bell, and I went out and I saw Craig Washington, and Bobby Bell was treating him so bad. It made me upset. He put him at the bottom of the list, was just treating him terribly. And I just couldn't understand why. And then somebody pulled me aside and says, you know, Bobby Bell's only lost one case in the history of him being a DA here in Bell County, which is what they called Jackson County. They called it Bell County because Bobby Bell dominated the courtroom. The Rusty Hardens, the Dick DeGarens, they all been out there and handed losses at the hands of Bobby Bell. But the only man ever to beat Bobby Bell in the criminal trial was Craig Washington. Courthouse legend. In what I understand was a racially charged case as well. And coupled him with Robert Elton Jones. Robert Elton Jones is a lawyer's lawyer. He's a guy who gives his time freely to people, someone who's won federal cases and someone who's won state court cases, someone who gives his all for clients. I remember a time I called Robert Jones as a young lawyer not knowing anything about how to do federal cases, and I had Judge David Hittner appoint me on a federal case, and I called Robert Jones, and he dropped everything and spent an hour and a half on the phone with me, walking me through what I needed to do for my defense. And I never forgot that, Robert Jones. I never forgot that. I try to do that with lawyers because of what Robert Jones did for me. He spent time outlining what I needed to do for the defense in the case, and he helped me not make a fool of myself. And I've seen him in cases and had him represent co-defendants, and he's advocated hard for his defendants as well. And if he's ever on a case with you, he's someone that is a great resource. And so I'm grateful that both of these brothers, who I look up to, who I want to be like when I get to be their agent. I'm sorry.
You're wrong for that.
I'm just messing with you, man.
That's all right.
Who I want to be like when I get to be to their stature.
Shit.
In all seriousness,
Yeah.
they're role models for us all. And I'm grateful that they came to speak to us and talk to us a little bit about the history of Batson.
Okay. Thank you. Thank you for inviting me. I don't like to use the word I a lot because whatever gifts I have, I realize that God gave them to me. So if I use I every once in a while, and I don't speak linear, I think circular. So when I repeat myself, I'm going to sit down. And I'm going to talk about a lot of stuff, and I know I'm preaching to the choir, and I got a little anxious sitting there because I got a lot to say. I don't come to the courthouse much anymore. Most of y'all know probably everything or most of the things I'm going to say, but I'm going to say them anyway just in case there's somebody, because sometimes there's someone in the crowd that doesn't remember or know what you're saying, and they're too timid to raise their hand because nobody else is raising them. So I'm just going to say what I got to say, and I'm going to sit down. First of all, everything in the courtroom is about race. I'm going to say it again. Everything in the courthouse is about race. Took me a long time to figure that out. Been coming down there a long time. I think, and this is just my opinions, it's all I'm expressing, not the opinion of the public defender's office. They disavow any knowledge of what I say and they claim to it. I think the minority lawyers ought to be out front on raising these issues. Because, be honest with you, I'm not afraid of anything. But I always feel funny when I stand up and have to make the Batson claim because I'm expected to do it. But think of the beauty of a young, I don't use terms, you know, I wasn't raised like that, but non-minority person. Think of the power of you standing up and making a Batson challenge. First of all, Batson is about the jury. It's not about the defendant. It doesn't matter what race the defendant is. If you're a white lawyer trying a white defendant, you got just as much right to have black people and Hispanic people on your jury as anybody else. So don't just sit there and let them strike all the black people because black doesn't have anything to do with your client. It's about a cross-section of the community. Batson is for jurors, for citizens. It's not for defendants. Doesn't matter whether, if you got a black defendant, a Hispanic person gets stricken, say something about it. Say something about it. You got to teach these judges what the law is, and the way you teach them what the law is by doing your job as a lawyer. And I'm not saying you're not doing your job now, but start out early, tilling the soil, even before you get ready to go to trial. You don't have to do it anymore because Senator Whitmire passed the bill to change the grand jury composition that I introduced in 1975. In 1975, because when I came to the courthouse, a man named Ned Wade took me and put me under his arm. I don't know why. Most of you never heard of Ned Wade, never saw him.
I heard of him.
But one thing that he did do, people mistook him because he dressed in a gaudy fashion. His hats would match his suits, but he was smart as hell. And when he got ready to waive a jury, he put a piece of paper in front of the defendant and said, hey, boy, come on, sign this paper and waive your right to an all-white jury. It sounded funny, but it wasn't. Those of us who were over at 301 Sanders Center when that was a courthouse. Imagine what it's like to grow up believing in the Constitution. I don't know why you went to law school. But imagine reading all those cases about swimming pools and restaurants. And I hope that by this time, y'all wouldn't be confronted with this by the time you came along. Young man, probably 30-something. You? Yeah. 36. I had hoped that through the battles that other people had fought, that race wouldn't be a problem anymore, that it wouldn't be a problem at the courthouse, that you get fair cross-sections of jurors. You're not looking for anything special. You don't think that black people are going, if the evidence is overwhelming, they're going to turn some joker loose just because he's black? You know better. Some prosecutors still think that. That's not true. Like the example that Alvin Nunner recited. They're going to convict people that need to be convicted, you know. But if these people start out with the prejudice assumption in their mind that a black person is going to cut some black guy loose regardless of what he or she did, just for the hell of it because they have the same race, that's bullshit. But don't let that bullshit infect the jury selection process. So what I would do if I were you is I would start out early. Like I was about to say about the grand jury. I used to go look at the grand jury, who was on the grand jury that indicted them. There's not a fair cross-section there. Start there. When you file your pretrial motions, have a motion to shuffle already ready and in hand in your pocket. So when a panel comes in, if all the people that you want to think, regardless of what race they are the fair cross-section people are in the back, 34, 32 and beyond, shuffle the panel. Either side can shuffle the panel. Know the census data for Harris County. The last decennial census tells you how many of each ethnic group that's recognizable and recorded according to census data exist in Harris County to the exact percentage, not updated since 2010, which was the last census, but at least you start there. So if you got 16.7% blue people and there are no blue people on the panel, you start out raising hell about it right then. But you put the judge on notice and the prosecutor on notice, if they got any sense at all, that there's going to be a problem when we get to the end and you see an all-white jury, regardless of what race the defendant is. So you plant the seed early. I put down here, soften the ground. Look at the grand jury. Challenge the array. Nobody's ever had a challenge to the array granted, but in the Code of Criminal Procedure, there's a procedure for a challenge to the array. Don't you think that one challenge to the array would be if 50 orange people show up and no blue people show up, and there's 35% of the people who live in the county? You challenge the array of people who've been called for jury service. And it doesn't have to, And Alvin said it correctly, and I wish we could get past that one day. I guess we will. Once you raise the issue of race, everybody gets on edge on both sides. Believe me, black people get on edge too. I'm nervous when I'm standing there talking to a judge about the fact because he or she thinks I'm talking about him being a racist. This ain't got shit to do with them being a racist. You don't have to be a racist to not be able to see. Google IAT. Some of you probably heard of it. It's called the Implicit Association Test. Take it, regardless of what race you are. And you'll see how deeply race permeates everything that's going on in this country. IAT. It's a test that requires you to instinctively respond to things that pop up on your computer. Black, bad. White, good. It's there. And test yourself, no matter what race you are. You're not going to make 100. Black people are not, Asian people, Hispanic people, nobody's going to make 100 because it permeates all of us. Once you recognize that it's there, you can shed yourself of the blame of trying to say, it's my fault. It's not about race. It's about a fair cross-section of the community. I've never met a lawyer who thinks if I can get these black people on the jury, they're going to find this joker who's guilty as hell not guilty. No. But the trial's more than about that. It's about punishment. It's about empathy. It's about understanding. It's about going back in the room and not having somebody say the word nigger back in the back room. That's what it's about. If there's a black person back there, it's not going to happen. I call that the